All right, Monday, court filings just dropped. I've been going through them for the last 4 hours. According to court documents filed Friday, Pam Bondi, the former Attorney General of the United States, handed over communications, private communications, between her office and the White House. And a federal judge did not take it well. $2.3 million in withheld compliance funds, 127 pages of internal directives, a judicial order that landed Saturday morning. I've read through all of it. Here's what they missed. Quick context. Pam Bondi, former Florida Attorney General, then Trump's pick for U.S. Attorney General, confirmed in the second term. The issue? A federal judge is now claiming Bondi's DOJ actively concealed presidential directives that directly affected ongoing court proceedings. Not delayed disclosure, concealed. Timeline? Fast version. Weeks back, a whistleblower complaint surfaces inside the DOJ. Routed internally, goes nowhere. Shortly after, 3 separate motions filed in federal court demanding disclosure of White House communications related to enforcement decisions. Last week, those communications finally come out, and the judge's reaction tells you everything. That's the setup. Now, the documents. Okay, the evidence. First document, filed Friday. I pulled page 34. It says, quoting here, communications between the Office of the Attorney General and White House Counsel occurring between March 12 and April 19 were intentionally withheld from court-ordered discovery. That's not my interpretation. That's the filing. What it means? The DOJ knew a judge had demanded these records and held them back anyway. But here's what actually got me. Page 89, different section entirely. A handwritten notation in the margin of a forwarded email chain. 7 words. Per POTUS, do not produce this. 7 words. I went through this document 3 times. The pattern is clear. March 12, White House Counsel sends internal directive on immigration enforcement discretion. March 28, DOJ acknowledges directive in a reply, all chain. 23 people copied. April 3, DOJ tells the court no relevant communications exist. Put those dates together. Yeah. Now, what nobody's covering. The same 127-page filing includes a separate set of communications, not about immigration, about a federal contractor, a Delaware LLC, whose $18.4 million contract was quietly modified in February. Same week, the DOJ received the White House directive. Read that again. Same week. Fallout. The judge issued a contempt warning Saturday morning. 2 senior DOJ officials placed on administrative review by Sunday afternoon. Congressional Oversight Committee Chair sent a formal inquiry letter, arrived at Main Justice by 9 a.m. this morning. Within 48 hours, that fast. That's just the first document. Subscribe. I'm not done. Okay, but look, gotta be fair here. The other side has a point. Few points, actually. Bond's allies, and there are serious legal minds among them, say this is a selective reading of executive privilege law, that presidents have the right to communicate privately with their AG on enforcement priorities, that the judge is overstepping. And honestly, some of it holds up. Their argument, first, executive privilege is real. It's been upheld repeatedly, from Nixon through Obama through Trump's first term. Presidents and their AGs talk. That's not obstruction, that's governance. Second, the timing of the whistleblower complaint lines up suspiciously close to a congressional midterm campaign cycle. These things don't always surface by accident. Former Deputy Attorney General Stuart Morales, 22 years inside DOJ, put it this way. Courts have consistently held that enforcement discretion is an executive function, not a judicial one. Don't agree with all of it, but that's not nothing. What they've got, precedent on executive privilege going back decades, a legitimate argument that judges can't compel disclosure of core enforcement strategy. Even the federal judge assigned to the case admitted in a footnote, the scope of privilege here presents genuinely contested constitutional questions. Look, I'm not here to tell you who's right. The Bondi camp's interpretation, evidence supports it to a point. The judicial interpretation, evidence there too, and it's growing. Both can be true simultaneously. That's what makes this legally complicated. What I can tell you, what the documents show, and they show a judge who has now seen the communications in camera, privately, and decided contempt warnings were warranted anyway. This didn't come out of nowhere. Backstory, quick. About 8 months ago, Bondi's DOJ began quietly narrowing the scope of information shared in 3 separate federal cases. Nothing dramatic, small omissions, delayed productions. A few months later, 2 career prosecutors filed internal objections. Both were reassigned within a week. 1 resigned. 6 weeks before the current filing, a federal magistrate in the Eastern District flagged a discovery gap, sent a formal notice to Maine Justice, received a form letter back. Someone even said on record at a legal conference in Chicago, "There's a pattern here that I've never seen in 18 years of federal practice." What happened? The objections kept getting routed into a bureaucratic black hole. Pattern: disclosure requests met with executive privilege claims, then partial productions. Career staff concerns flagged internally, then reassigned. Judicial inquiries answered with form responses, then slow-watered. Every time, there was a way through it. Until Friday. See where this is going? Like this. Saturday, 7:43 a.m. Here's what happened. The judge issued an emergency order. No oral argument, no advance notice. The court finds substantial evidence of deliberate non-dot compliance with discovery obligations. Courtroom wasn't in session. This landed in written form, filed directly to the docket. What followed? Bondi's legal team had 4 hours to respond. The White House issued a 1-paragraph statement through the press office. The DOJ press secretary canceled a scheduled press briefing with no explanation. 4 hours, that fast. Now, what everyone missed. While the news cycle focused on the contempt warning, something else happened Saturday afternoon. The same federal judge unsealed a previously redacted exhibit, Exhibit 14C, a 2-page memo authored inside the White House Counsel's office explicitly referencing the ongoing litigation and advising Bondi's team on managing judicial expectations. Then it gets more specific. The memo references a timeline for resolution that aligns almost exactly with a political calendar event, a Senate confirmation vote scheduled for May 14th. The judge's response? Ordered a show cause hearing, not reactive, calculated. You can see it in the language of the order. Every sentence is precise, sourced, cross-referenced to specific exhibit numbers. This is where it gets legally interesting. Drop your prediction below. Then keep watching. What are experts saying? Former federal prosecutor and Eastern District veteran with 19 years experience, Jennifer Rao, was quoted in a legal journal Sunday. A show cause order after in-camera review is not a warning shot. It's a loaded one. Plain English, the judge has already seen what was hidden. The hearing is about consequences, not facts. Another one, former assistant U.S. attorney and constitutional law specialist at Georgetown, Dr. Marcus Ellery. When a court says manage judicial expectations appears in a White House memo, the privilege claim essentially collapses. You can't simultaneously invoke privilege and demonstrate you were gaming the process. Key there, the memo that was meant to stay hidden actually undermines the privilege argument. Here's what's interesting. Even a former DOJ official who publicly supports Bondi admitted on a Sunday panel, the Exhibit 14.C problem is real. That language is going to be very difficult to explain. When people on both sides agree the exhibit is a problem, pay attention. Consensus from legal analysts, the show cause hearing is likely to result in formal sanctions. The executive privilege argument weakens significantly with the unsealing of 14.C. Congressional oversight now has a paper trail that's hard to dismiss. That's where serious legal professionals are landing right now. Useful breakdown? Like it. Why should you care? Real talk. How this affects actual people. If you have retirement savings in a fund that holds federal contractor stocks, pay attention. The Delaware LLC at the center of the modified contract has secondary relationships with 4 publicly traded defense and logistics firms. When a $18.4 million contract modification gets scrutinized in a contempt proceeding, the downstream exposure expands. Auditors follow subpoenas. Subpoenas follow sealed exhibits getting unsealed. Your 401k? Probably not direct exposure. But the precedent on how White House-directed contract modifications get reviewed, that changes the risk calculus for a lot of federal contracting. This sets a real legal precedent. Next time you're a party in a federal case where the government is on the other side, the rules on what they have to disclose just became a live constitutional debate again. Say you're a small business owner with a federal contract dispute. Under current precedent, you can compel certain communications. If this case shifts that line through appeal or Supreme Court review, your ability to get documents that affect your case changes. Not hypothetical. That's how precedent works. Right now, an estimated 340,000 active federal civil cases involve some form of government side disclosure obligation. Federal public defenders have already begun filing motions in at least 6 districts, citing Friday's filing as grounds for expanded discovery. It moves fast. Uncomfortable part. If this ends in a successful contempt finding, meaning sanctions with teeth, it will be the first time a sitting attorney general's office has faced formal judicial contempt in a discovery matter in over 30 years. If you vote, pay taxes, or have ever had any interaction with the federal legal system, this is your system behaving in a way that a federal judge found alarming enough to act on a Saturday morning. Not trying to alarm you. That's what the documents suggest. What informed people are doing right now. Legal advocates are monitoring the May 7th show cause hearing docket. Congressional staff are cross-referencing the Exhibit 14C memo with committee testimony from February. If you're a federal contractor, it's worth asking your compliance team whether similar White House communications exist in your documentation. Knowledge helps here. How did Bondi respond? Made it worse, honestly. Saturday afternoon, through a spokesperson, the official position was that all court obligations have been met in good faith. Quote, the department stands by its productions and will respond appropriately through proper legal channels. Reaction? That statement arrived 5 hours after the contempt warning. The judge's order had already been publicly docketed before Bondi's team acknowledged it publicly. The opposing counsel came back within the same afternoon. Good faith and Exhibit 14.C cannot both be true. Then Sunday, the White House issued a second, longer statement, this one actually citing case law, which means their legal team spent Saturday night drafting arguments, not cooling down, heating up. What's still unclear. 1, we don't yet know the full contents of the in-doc camera review. The judge saw something that escalated from standard non-doc compliance to emergency show-doc cause. We don't know exactly what triggered that escalation. The sealed portion of Friday's filing hasn't been released. 2, the Exhibit 14.C memo is 2 pages, but it references an attachment labeled Schedule A. Schedule A has not been unsealed. That could be nothing, or it could be the document that explains everything. Coming, the federal judge has the show-doc cause hearing scheduled for Thursday, May 7th. Bondi's legal team is reportedly preparing a formal executive privilege assertion, a full legal brief expected to be filed by Wednesday, May 6th. The Senate Judiciary Committee chair has requested all documents referenced in Friday's filing by Friday, May 8th. Date to watch, Thursday, May 7th, that show-doc cause hearing. We should know significantly more by end of day Thursday. Subscribe. I'll cover the update when it drops. Where we are right now, Monday, May 4th. Federal contempt warning issued and docketed as of Saturday, May 3rd. Bondi's DOJ officially maintaining the good faith position, preparing privilege brief. Exhibit 14.c, unsealed and public, available on Pacer right now. Schedule A attachment, still sealed. Congressional inquiry, formally sent to Maine Justice this morning. 2 senior DOJ officials on administrative review pending internal investigation. Scheduled Wednesday, May 6th. Bondi's legal team, privilege brief deadline, Thursday, May 7th. Federal show.cause hearing, 10 a.m. Eastern, Friday, May 8th. Senate Judiciary document request deadline, Tuesday, May 13th. Next scheduled status conference in the underlying case. Not yet public. The full scope of the in-dock camera materials the judge reviewed before issuing Saturday's order. Clock is running. That's where we are. Pam Bondi's DOJ facing its first formal contempt proceeding in this administration. Surface read, a discovery dispute between a federal judge and the Justice Department. But the Exhibit 14.c memo shows the White House Counsel's office was actively involved in how Bondi's team managed its court obligations. That's not normal. And a federal judge, after reviewing those communications privately, decided Saturday morning couldn't wait. I'll be watching Thursday's hearing closely, specifically whether the judge accepts the privilege assertion or rejects it outright. That's the hinge point. Story's not over. Still developing. Subscribe for the full picture, not just the headlines. When the documents drop from Thursday's hearing, I'll break them down. Talk soon.